could he confirm the reports that were in the paper that the Home Office is now seeking to pay people to go to Rwanda in order to fill the flights? And could he confirm that if people do take up that Home Office proposal, they will be subject to exactly the same payments to the Rwandan government, the very substantial payments to the Rwandan government? And will it also be covered by the capacity questions in the treaty?
Well, Mr. Speaker, that's not directly relevant to Amendment 8, respectfully. The answer in terms of voluntary removals is that, yes, it's in exactly the same way. There were voluntary removals, 19,000 last year, voluntary removals all the way back since the dawn of time, or possibly even more. There is nothing new. The novel part, if you like, if the Honourable Lady would care to listen, the novel part is that there will be voluntary removals to Rwanda. That is absolutely right. Specifically in relation to Amendment 8, it is not necessary to report the number of removals to Parliament, and we do not consider obligations to report to Parliament to be appropriate. I'm going to continue. In relation to Amendment 9, this would act to impede provisions already recently passed in the Nationality and Borders Act and the Illegal Migration Act. Mr. Speaker, the amendment is unnecessary. It is important to be clear that the government of Rwanda has systems in place to safeguard relocated individuals with a range of vulnerabilities, including those concerning mental health and gender-based violence. Furthermore, Mr. Speaker, under Article 13 of the treaty, Rwanda must have regard to information provided about relocated individuals relating to any specific needs that may be arised as a result of their being a victim of modern slavery or of human trafficking, and must take all necessary steps to ensure that these needs are accommodated. In relation to Amendment 10, Mr. Speaker, Amendment 10, the government greatly values the contribution of those who have supported us and our armed forces overseas. That is why there are legal routes for them to come to the United Kingdom. It remains the government's priority to deter people from making dangerous and unnecessary journeys to the United Kingdom. Anyone who arrives here legally should not be able to make the United Kingdom their home and eventually settle here. A person who chooses to come here illegally, particularly if they have a safe and legal route available to them, should be liable for removal to a safe country. Having said that, I haven't given way to the honourable gentleman. Yes, of course I'll give.
I thank the Minister for giving way, because he did seem to try and brush over some of the costs involved. And is the Minister aware that Virgin Galactic can send 6 people into space for less than this government wants to spend sending 1 person to Rwanda? Is it not time to rethink this absurd policy and extortionate cost?
Directly in terms of costs, we had a debate on Thursday on the cost of the scheme. And, Mr. Speaker, not a single Labour backbencher was there for that debate. There was only the Honourable Lady who proposed that debate and only the Minister who responded. And, of course, the Honourable Member who moved the motion, who I don't treat as an ordinary backbencher because she's the chair of the Select Committee. It was her debate. Not a single other Labour backbencher was there. That shows the priority, or the lack of priority, which those opposite give to that. In relation to Amendment 10, the IMA passed by Parliament last year enables in Section 4 the Secretary of State by regulations to specify categories of persons to whom the duty to remove is not to apply, whether on a temporary or on a permanent basis. And for those who are not in scope of the IMA, the Home Secretary has discretion to consider on a case-by-case basis where circumstances demand it. Mr. Speaker, I want to reassure Parliament that once the UKSF and the ARAP review has concluded, the government will consider and revisit how the IMA and removal under existing immigration legislation will apply to those who are determined to be eligible as a result of the review, ensuring that these people receive the attention that they deserve. Mr. Speaker, the government recognised the commitment and the responsibility that comes with combat veterans, whether our own or those who showed courage by serving alongside us, and we will not let them down. Mr. Speaker, the bill and the legally binding treaty will make it clear that Rwanda is a safe country to which we can swiftly remove those who enter the United Kingdom illegally. It addresses the factual concerns identified by the Supreme Court. It provides for clear, detailed and binding obligations in international law on both parties. It will prevent systematic legal challenges about the safety of Rwanda from frustrating and delaying removals. And it provides a strong deterrent, as my honourable friend, the member for Gloucester, set out, and a clear message to illegal migrants and the criminal gangs that if you come to this country by unlawful means, you will not be able to stay. Mr. Speaker, I beg to move.
The question is, this House disagrees with Lords in Amendment 1. Shadow Minister Stephen Kinnock.
Thank you very much, Mr. Speaker. And I rise today to speak in favour of all 10 of the Lords' amendments that are before us today. They each serve to make this shambolic mess of a bill marginally less absurd. And as I will come to in a second, they would serve only to put in statute what ministers have actually promised from that dispatch box. Not one of these amendments is designed to prevent the departure of flights to Rwanda, as the Prime Minister has repeatedly and wrongly implied that they will. Mr. Speaker, we all want to end the Tory small boat chaos. And I am proud that the Labour Party has consistently put forward a smart, pragmatic and sensible plan to do so, starting by going after the criminal smuggler gangs at source through a new cross-border police unit and a new security partnership with Europol. But this bill and the treaty which accompanies it will not contribute in any way to achieving that aim, because
This is the government. I'm very grateful for him giving way on that point. Since 2020, we've seen 82 gangs disrupted and over 400 people arrested because of the actions of this government. I'm keen to understand, with Labour's idea of smash the gangs, how many more they expect that to be, how much more that will cost, and what does that look like in a total percentage of numbers?
We will eradicate the activity of the criminal smuggler gangs by having a proper security partnership with our European partners and allies. I'd remind the honourable gentleman that his party has spent the last 8 years trashing and destroying our relationships with our European partners and allies. So what we would have with a Labour government is a basis of trust to get the results that we need to see for the British people. That is what sovereignty is all about, Mr. Speaker. Because the entire Rwanda debacle has absorbed a vast amount of time, energy and money that should instead have been focused on taking back control of our border security from the criminal gangs who are trading in human misery. And let's not forget that more than 100,000 asylum seekers have crossed in small boats since then, with 40,000 on this Prime Minister's watch alone. This chaos must end. And this government is clearly unable to restore order at the border. So it's clearly time for them to get out of the way so Labour can get the job done. Mr. Speaker, before I get into the substance of the amendments, I'd like to pay tribute to the noble members of the other place who tabled them. In so doing, they were fulfilling their constitutional, democratic and patriotic duty by scrutinising and seeking to amend this bill just as they would any other piece of legislation that comes before them. They have not been intimidated or sidetracked by the Prime Minister's mistaken assertion that this legislation should have some kind of special status or treatment, which should somehow allow ministers to railroad it through Parliament and drive and coach and horses through Britain's long-standing democratic conventions. Indeed, this profoundly dismissive attitude has manifested itself in the way in which the government has point-blank refused to engage with these Lords' amendments, rejecting every one of them, rather than seeking to use them and see them as a basis for negotiation and compromise. I will give way.
I'm most grateful to the honourable gentleman. Is he aware of the fact that the Constitutional Committee of the House of Lords, which does in fact include a significant number of the members of the House of Lords to which he's just referred, actually quite explicitly stated in relation, and I'm speaking here about Amendment 1, Clause 1, that where it is clear and unambiguous in the words used in a statute that international law gives way to the supremacy and sovereignty of the United Kingdom Parliament. They said it in paragraph 58 of their report only last year.
Well, what I would remind the honourable gentleman of is that the Supreme Court, the highest court of our land, has ruled unanimously and in no uncertain terms that Rwanda is not a safe country to which to send asylum seekers. And I recognise, I know he's very taken with parliamentary sovereignty, and that's very important. Parliamentary sovereignty must be based on paying due regard to the findings of our judiciary, and it is to be exercised with caution and moderation, Mr. Speaker, and that is why it's so important that our colleagues in the other place have played this role. I will give way one more time.
I am extremely grateful, because this is right at the heart of this matter. In the Rwanda judgment itself, in paragraph 144, it is unequivocal that the Lord President of the Supreme Court ruled the dismissal of one of the cases, ASM, an Iraqi, on very specific grounds, and he said that because of the sovereignty of Parliament with respect to the legislation under the Immigrations Act and the Retained EU Law Act, the consequence was that they had to dismiss his claim precisely because in that judgment, the supremacy of Parliament prevailed for the very reason I've just given, and that is at paragraph 144 under the principle of legality.
Well, I thank him for his intervention, but at the end of the day, you cannot legislate to turn dogs into cats. You cannot legislate for the sky to be green and the grass to be blue. And it is a basic tenet of the respect with which our institutions should be treated that to put this kind of absurd legislation before us is frankly turning our institutions into a laughingstock. So I would respectfully suggest that the honourable gentleman keeps that in mind. Now, let's be clear, Mr. Speaker, the only special or unique status in terms of the aspects of this bill and the treaty that accompany it that can be found are in its extortionate implementation costs, its unlawful nature, and its glaring unworkability. Indeed, as I move into the details of these amendments, I feel it's important to point out that since the Rwanda bill was last debated in this place, even more evidence of the astonishing unaffordability of the scheme has come to light. This failing scheme was already costing the British taxpayer almost £400 million, even though not a single asylum seeker has been sent to Rwanda. But every new detail is more astounding than the last. And we recently learned that the first 300 asylum seekers to be sent to Rwanda would cost the British taxpayer an extra £200 million on top of that, earning an invoice worth £570 million from the Rwandan government for just 1% of the 30,000 asylum seekers who crossed the small boats last year. That's almost £2 million per asylum seeker. Just let that sink in for a moment. £2 million to send just one asylum seeker from the UK to Rwanda. And then another 100, I will in 1 second, and then another 182,000 per person on top of that. In comparison, to process an asylum seeker in the UK, in comparison, it costs just £21,000.
I'm grateful to my honourable friend for giving way. He will be aware of the thousands of asylum seekers that are being dispersed up and down the country with very little support to local services. So while the government is obsessing with gimmicks that are not dealing with the real problems in communities and supporting local communities to host that they are dispersing up and down the country, this crisis continues and they need to get a grip on it.
I thank my honourable friend. She's absolutely right that the smoke and mirrors that's been used about clearing the backlog, lots of administrative withdrawals, lots of other ways of just getting people out of the backlog, is being combined with shortening the eviction period, which is leading to a staggering increase in homelessness amongst those who've been granted asylum. It is frankly a stain on the conscience of our country, what's happening with that, a total lack of coordination between the Home Office, DLUC and our colleagues in local authorities, and it is leaving our local authorities high and dry. I will give
I thank him for giving way. Whilst I might not share many of the views which he's expressing in this bill, does he not share my surprise that the government has refused to accept Amendment 8, which would have required it to report on the success of this bill, where the number of removals would be reported to Parliament, yet the government doesn't want that. Does he suspect that, like I, that maybe the government knows that this bill is not going to be as effective as what they think it's going to be?
Well, I thank the honourable gentleman. That's an excellent question, and who knows? Perhaps sometimes the mask slips in terms of the government's response to some of these amendments. The reason they've decided to very disrespectfully refuse to engage on any of them is perhaps because, exactly as he says, they are very worried about what might happen if they do. When you lift the lid on the box, you see that it's a total failure inside it.
On that point, I do thank the Shadow Minister because he's making an excellent speech. But let us not forget history. The Tories' Rwanda bill is the third new law on channel crossings in just 3 years. Mr. Deputy Speaker, the first law has only been partly suspended because it had so many problems and it was actually making things worse. The second bill has still not been fully enacted. And this is a third bill, another gimmick at £2 million per person cost to the public purse. And does my honourable friend agree that rather than constantly chasing gimmicks and trying to dupe the British public, that the government finally needs to get a grip on the situation and stop pursuing these gimmicks?
Well, I thank my honourable friend for that intervention, and I agree with every word of what he said. Just imagine if the amount of time and money and resource and energy and political capital that has been burned on this harebrained Rwanda scheme had been used on doing things that might actually deliver. And just imagine if they'd listened to Labour's plan for delivering the change that we need to see, we might have actually got some progress and seen things working. And by the way, we've supported what the government's done on Albania. Why don't we see more of that rather than this utterly ridiculous government by gimmick? What a waste of time and money. Now, the level of waste and this government's cavalier attitude to taxpayers' money are utterly staggering. And where, oh, where is the plan for the other 99% that they say are going to be inadmissible? Tens of thousands of people who are now ineligible to be processed, ineligible to claim in our asylum system, but they can't be sent to Rwanda either. That particular backlog, the so-called PERMA backlog, currently stands at 56,000 people, with most of them living in more than 300 taxpayer-funded hotels across the country, costing millions of pounds every single day. Which is why
I thank the honourable member for giving way. You make a very powerful argument about the wasteful nature of this government's policy. Is my friend aware that the £2 million cost per person of sending someone to Rwanda would cover 67 new police officers in my constituency or 72 new nurses to fix the horrendous backlog created by this shambolic government?
Yeah. Well, I thank my honourable friend for giving way. He's absolutely done his maths on the £2 million. I did particularly enjoy the analogy with the Virgin Galactic space and craft, and that really does show that the Rwanda plan is a galactically wasteful policy. But he's quite right on the fact that so much of this is about choices and priorities, and the choices and priorities that the government has shown are simply the wrong ones in terms of wasting very valuable taxpayers' money that could be so better focused elsewhere. And that is why we support Lord's Amendment 8, Mr. Speaker, which is a Labour frontbench amendment in the name of the noble Lord Coker. This amendment requires the government to report on the timetable for removing inadmissible asylum seekers under the Illegal Migration Act. We absolutely need to see accountability over the inadmissibility provisions that have created that PERMA backlog of 55,000 small boat asylum seekers stuck in limbo, unable to be processed. So perhaps the Minister could tell us now, if 99% of the people crossing in small boats are not likely to be sent to Rwanda, then what will happen to them? Will the Minister just now admit that in spite of all his bluff and bluster, they will simply be let into our asylum system after all? I don't know if he wants to. No. The whole premise of inadmissibility was always a one-way street to limbo and shambles, as the Shadow Home Secretary and I have warned the ministers in this chamber continuously over the past 2 years. There is, of course, an alternative. I hope members opposite have been listening, because for the last 18 months at this dispatch box, myself and my right honourable friend, the Shadow Home Secretary, have been absolutely clear on how Labour will prevent the dangerous and life-threatening channel crossings, and how we will also fix our broken asylum system. I've already mentioned how we would redirect the money set aside for the Rwandan government into a cross-border police unit and intelligence sharing security partnership with Europol in order to smash the criminal smuggler gangs upstream. But as part of our plan, we would also ensure people who have no right to be here are removed to a safe third country. Since 2010, under the Tories, removals have collapsed. The returns of foreign national offenders have fallen by 27%, and the returns of failed asylum seekers have fallen by 44%. Under Labour's plan, a new returns and enforcement unit would include 1,000 additional officials to expedite removals, with £35 million set aside to create new Nightingale courts to fast-track appeals and to pursue tougher action on employers who employ migrants illegally.
I thank the Shadow Minister for giving way. He says he wants removals to a safe third country. Which one?
I thank the honourable. I'm very sorry. Would the honourable member just mind repeating that?
Oh, thank you. Well, it's always good to listen to an intervention, but I'll repeat it for him. He said one of these parts of his plan was to remove people to a safe third country. Simple question. If not Rwanda, which one?
I apologise. It should have said home country. I should have said home country. I misspoke, and I'd like to correct the record. I'm sorry. It was home country. Apologies. I misspoke there. Labour's common sense, pragmatic plan will smash the business model of the criminal gangs, deter dangerous journeys, and tackle the backlog. Mr. Speaker, I will in 1 second. With your permission, I will now run through the remaining 9 amendments that have come to us from the other place. We support each of them for the reasons that I will now set out.
I'm grateful for giving way. How much would Labour's plan cost?
As I've already said, I don't know if the honourable member was listening, this is about repurposing the vast quantities of taxpayers' money that are being squandered on his harebrained Rwanda plan, and that rechanneling of that money will fund the clearance of the backlog, the sorting out returns, and smashing the criminal gangs. Now, I would first like to focus on Lord's Amendment 10, tabled by the noble Lord Brown. This amendment seeks to exempt individuals who have worked in support of the UK government or armed forces from removal to Rwanda under the provisions of this bill. This amendment is driven by a moral imperative, Mr. Deputy Speaker. We owe a debt of gratitude to those who have supported our defence, diplomacy and development abroad, not least in Afghanistan. And it beggars belief that the government would even consider sending this cohort of heroes who are fleeing the Taliban to Rwanda. Britain's commitment towards these loyal to Britain Afghans is, of course, felt most strongly by our own armed forces. But this government has continually shirked its responsibilities towards Afghans, including by leaving thousands of those with a right to be in the UK stranded in Pakistan for more than a year. Little wonder that they have resorted to making these desperate journeys across the Channel. Operation Warm Welcome has become Operation Cold Shoulder, Mr. Deputy Speaker.
Talking about he wants more Afghanistani people to come from Pakistan to the UK. How many more immigrants does he want to come to the UK from Afghanistan?
Well, the amendment is about stopping them being sent to Rwanda, but let's be absolutely clear. There are many, many Afghans who have been identified by the government under the ARAP and ACRS schemes. Those are the people that are languishing in Pakistan because this government we of course remember the Prime Minister's memo to Whitehall saying, by the way, everybody, let's slow pedal on these Afghans who are in Pakistan who have been identified for resettlement under the ACRS and ARAP. So if he wants to know the number, I recommend that he goes to his own government and asks how many have been identified under ARAP and ACRS. I will give way.
I'm grateful to him for giving way. In my own constituency, I met one family who were in a similar situation where the constituent's husband had been killed in Afghanistan, is still in this limbo land because of the delay in decision making. And also, is he aware that there is now a situation where Pakistan is forcing Afghan asylum seekers back to Afghanistan, and there are tens of thousands of people in that situation, some of whom will be those who worked to support our forces during the war in Afghanistan.
Well, and that, of course, my honourable friend is absolutely right, because that is the scope of this amendment tabled in the name of Lord Brown, is specifically for those who served shoulder to shoulder with our armed forces and our diplomatic and our development efforts in Afghanistan. So these are people to whom the United Kingdom owes a debt of honour and a debt of gratitude. I'm not sure honour is a word that we can apply very easily to the benches opposite, but that is what it's about. Lord's Amendment number 9, in the name, yes, thank you. Lord's Amendment number 9, in the name of the noble Baroness Butler-Sloss, is also based on a moral imperative, Mr. Deputy Speaker, as it would prevent the removal of potential victims of modern slavery to Rwanda until they receive a decision from the government on whether there is credible evidence that the person is a modern slavery victim. It really should go without saying that modern slavery victims should not be being sent to Rwanda. But sadly, with this government, basic moral decency is a scarce commodity.
On both 9 and 10, can I just say, those of us who've dealt with both traffic victims and also those of us who've dealt with those who served us in Afghanistan, this indicates some loss of moral compass here somewhere. And with regard to those who served us in Afghanistan in a whole range of different functions, they have survived just to get out of the country, having been chased by the Afghani security, well, Taliban. Their families have been harassed. Some of them have got to Pakistan and then been threatened with force back over the border again. They've got to us traumatized, and we're going to traumatize them again by sending them to Rwanda. This cannot be right, and I can't believe honourable members who've dealt with any of these cases could not support these amendments, because it's human suffering in the extreme, but particularly with those who've served us, human suffering brought about by their loyalty to us.
Well, I thank my honourable friend for that intervention, and he makes the case with passion and conviction. I know that he also has a number of asylum seekers and refugees in his constituency, and he does a huge amount of work on their behalf. I think he's absolutely right that there are some issues which should really transcend the day-to-day political considerations that we have in this place, because they are issues that are based on moral imperatives. And it is deeply disappointing that in both of these amendments that he mentions, the government has refused to even have the basis for a negotiation or some kind of compromise to allow. And we do find that deeply disappointing. I will give
Would you agree with me in answer to the earlier questions posed to him, how many? That the simple answer is all those who served, who risked their lives to help us in a war which required the support of the local population. Those people, if they're in danger, and if we've got records of the help that they gave and the support which they gave, surely we can't turn our back on those individuals.
I thank the honourable gentleman, and what a contrast between his intervention and the intervention of the gentleman on the other benches. I genuinely believe that when the gentleman on the opposite benches reflects, he will regret the intervention that he made, and perhaps he could reflect on what the honourable gentleman on the bench behind said. We on these benches are also profoundly concerned about unaccompanied children being inadvertently sent to Rwanda. For this reason, we support Lord's Amendment 7 in the name of the noble Baroness Lister, which reverses changes to age assessment procedures established by the Illegal Migration Act in relation specifically to removals to Rwanda. It restores the ability of domestic courts and tribunals to fully consider suspensive judicial review claims regarding removal decisions taken on the basis of age assessment of unaccompanied children. Lord's Amendments 1 to 6 all relate to the rule of law. We support all of these amendments, and they are all principles that government ministers have said that they agree with. Indeed, the simple question that should be asked in relation to each one of these amendments is this: if ministers believe that Rwanda is a safe country, then why is the government refusing to support these amendments? They say that this bill abides by international law, so why not just make that clear on the face of the bill? They say that Rwanda is a safe country and is meeting its obligations. So let's see the evidence and agree but a trust but verify mechanism. In this spirit, Lord's Amendment 1 is a Labour frontbench amendment which places a responsibility on the government to comply in full with its current obligations under domestic and international law. Lord's Amendment 2 and...
I'm grateful to the honourable gentleman for giving way, but does he not accept that Amendment 1 is entirely OTOs? In terms of compliance with domestic law, this bill, when enacted, will be an element of domestic law. And in terms of compliance with international law, isn't it the case that it's predicated on international law, that is to say, the Rwanda Treaty?
Well, if that's the case, then why aren't government ministers accepting the amendment? I mean, it is simply those with a great deal more constitutional expertise than I in the other place, seeking reassurances that our democratic conventions, that our obligations in terms of alignment with the rule of law, will be respected. And as the honourable gentleman has pointed out, if that's the case, then surely these amendments should be perfectly acceptable to the government.
I thank the member for giving way. Perhaps I can help shed light on this, because the government minister has just shown that the government is not abiding by its international obligations. The Good Friday Agreement explicitly commits us to working together, those words are in it, with the Irish government when it comes to the rights of individuals in Northern Ireland. This piece of legislation will deny rights to individuals in Northern Ireland, and yet the government minister has admitted they have not even consulted the Irish government. So does my honourable member agree with me? Our word is our bond as a country, and if we show we can't be trusted to stand up for international law, it's absolutely right that this place demands the government puts it on the face of a bill.
Well, I agree with my honourable friend. She makes a very clear case. I would also say, of course, there's a lot of rhetoric that has accompanied this bill around the ECHR and the United Kingdom's obligations in international law, and the implications of that for the Good Friday Agreement are truly chilling. The way in which the benches opposite are prepared to sabre rattle and use rhetoric in a way that undermines our reliability as a partner that can be trusted to respect our international legal obligations is frankly shameful and deeply concerning, and not least in the case of the Good Friday Agreement. Lord's Amendments 2 and 3, in the name of the noble Lord Hope, state that Rwanda may only be considered to be a safe country if and when the measures set out in the Rwanda Treaty have been fully implemented, and the Monitoring Committee has established that this is the case. The government claims that the measures in the treaty address concerns in the Supreme Court's recent ruling, so there is absolutely no reason why ministers should refuse to accept Lord Hope's amendments. Lord's Amendments 4 and 5, in the name of the noble Lord Anderson, state that Rwanda can be considered a safe country unless there is credible evidence to the contrary, as determined by a court or tribunal. Following the Supreme Court's ruling, the government itself accepted that the situation in Rwanda is not static, but evolving, as it is in every other country on the face of the earth, Mr. Deputy Speaker. So if the government accepts that Rwanda could one day become safer for asylum seekers that are sent there from the UK, it must by definition also accept that it could one day deteriorate. Lord Anderson's amendments simply provide a basis for assessing the situation on the ground in Rwanda and acting accordingly. Finally,
Friend for giving way. A joint statement signed by over 260 civil society organisations has branded this bill, quote, a constitutionally extraordinary and deeply harmful piece of legislation that threatens the universality of human rights and is likely in breach of international law, striking a serious blow to the UK's commitment to the rule of law. Would my friend agree that this bill represents an unethical gimmick that will potentially put vulnerable people, very vulnerable people at risk and harm the UK's reputation on the world stage?
Well, I thank my honourable friend for that intervention, and she's absolutely right. And just think if, as I was saying, if the amount of time and energy that's been wasted on this madcap bill, which is also a constitutional outrage, unaffordable, unlawful and unworkable, had been actually put into addressing some of the challenges that we face in a pragmatic way, just think where we could have got to by today. So finally, the Lord's Amendment 6, in the name of the noble Baroness Chakrabarti, allows government ministers, officials and courts to consider whether Rwanda is safe on a case-by-case basis. Given that the government has accepted that some appeals will be allowed, we see no reason for the government to reject this amendment. Mr. Deputy Speaker, after 14 years of incompetent and negligent governance, our asylum system is in a mess. The Conservatives have presided over a backlog of 130,000 asylum seekers, despite ministers attempting to pull the wool over the public's eyes through administrative withdrawals and various other ruses. There are still 46,000 asylum seekers in taxpayer-funded hotels, contributing to an asylum system which now costs 10 times what it did under Labour at an eye-watering £5.4 billion. And only last week we discovered there were major problems with a broken immigration IT system, which has mixed up details of applicants affecting a staggering 76,000 people. But this con of a bill is not the way to fix the problems that this Conservative government has created. The highest court in our land has ruled unanimously that Rwanda is not a safe country, and no amount of ludicrous legislation like this bill can change that fact. The government may well wish to say that the sky is green and the grass is blue, but introducing an act of parliament will never make it so. And even the benches opposite recognise this bill is on a hiding to nothing, Mr. Deputy Speaker. Indeed, a former Home Secretary has stated that it is highly unlikely to work, and the former Immigration Minister has described the government's aim as being to get a few, and I quote, symbolic half-filled flights taking off this spring, rather than having a plan that is a genuine attempt to tackle the dangerous channel crossings. So it is probably also no surprise that ministers are finally now turning to Plan B, paying people a reported £3,000 per head to go to Rwanda instead. Can this really be true? And if so, would the minister like to take the opportunity to enlighten the House today on some of the details? Would this £3,000 per head come on top of the £570 million cost we already know about? Will there be another treaty between the UK and Rwanda to implement this? And if so, will he publish it? Have the NAO done an assessment of these additional costs? And will the House be able to vote on this new plan that has been briefed? I await the minister's responses with interest. Mr. Deputy Speaker, this bill is a con. The treaty is a con. The whole Rwanda plan is a con. It is quite simply a headline-chasing gimmick, as unworkable as it is unaffordable. The country knows it. This House knows it. The Home Secretary knows it. And the minister knows it. At £2 million per head, the Rwanda scheme is the worst value for money policy in history. But the amendments that I have spoken to today will not stop flights taking off. We expect those flights to happen this spring, as the Prime Minister has repeatedly promised the country. These amendments simply seek to insert into the bill what ministers have promised. So I encourage members on all sides of the House to join me in the division lobbies supporting these amendments later today. Thank you very much.
Order. Just before we proceed, the government and opposition front benches have perhaps understandably taken a certain amount of leeway in a broad brush approach to this debate. Can I remind the back benches that we are now debating Lord's amendments? This is not a second reading debate. So Jeremy Wright.
Thank you very much indeed, Mr. Deputy Speaker. And can I begin with an apology to you and to others in the chamber for the fact that I will not be in the chamber for some part of this debate due to some other parliamentary business I have to attend. But I want to start my remarks by recalling that the fundamental purpose of this bill is to locate the decision on whether Rwanda is a safe country to send people to with Parliament, rather than with decision makers in individual cases or with courts reviewing those cases. And I say that, Mr. Deputy Speaker, because a number of the amendments before us today seek to undermine that fundamental purpose by transferring decisions on that question away from Parliament again and back to the caseworkers and courts. And so they are, I'm afraid, wrecking amendments. They are incredibly elegant wrecking amendments, and they come from an honourable and fundamental opposition to the purpose of the bill, and an opposition which, Mr. Deputy Speaker, I entirely understand. I will confess to the House that I did not find voting for this legislation a comfortable choice. It comes very close to the line on rule of law acceptability, but in my view stays just the right side of it. And crucially, it asserts parliamentary sovereignty on an issue of huge political significance where that issue is central to the delivery of a key government policy. And that significant and central issue is whether the government of the day is entitled to pursue a policy on illegal immigration that contains an element of effective deterrence. And I think the government must be able to do that. And for a deterrent to be effective, it must be clear. The deterrent to those who are really economic migrants seeking to reach the UK under cover of our asylum system is that they may end up in a different country instead, in this case, Rwanda. In order for that deterrent to be meaningful, the prospect of transfer to Rwanda must be a real one, which it is not easy to evade, which means the headline judgment on Rwanda's safety must be clear to all, subject, of course, as it should be, only to persuasive individual circumstances. Mr. Deputy Speaker, I think that approach is worthy of support for two reasons. First, that illegal migration is a huge problem that the government must be able to pursue innovative solutions to, especially in the absence of credible alternatives. I give way to one of the
Fulton giving way, and he's making an excellent point about how we have to have innovative ways. Isn't it this the reason why other countries are looking at what the UK is doing? The likes of Austria, Germany, and Italy have all talked about using third nations, because there needs to be a solution to this problem that he's so elegantly putting out.
I think one friend is right. I'm conscious, Mr. Deputy Speaker, not to trespass into second reading territory, but he's right about that. And of course, as our right honourable friend, the Minister, has pointed out, other international agencies also make use of Rwanda for these purposes. But the second reason that I think this approach is the appropriate one is that the judgments about the safety of Rwanda in the terms of the bill are ones which at this point Parliament is as able to make as any other body. And at this point, I should say I'm grateful for the information with which we have been provided, including the country information notice that was referred to earlier in the debate, which in my view supports the conclusion that Rwanda is safe for the purposes of the bill. But Parliament's decision-making, Mr. Deputy Speaker, on the safety of Rwanda must have integrity not just for now, but for the future too. And I am, I have to say, troubled by what I might describe as the absolutist, if not the eternalist nature of the wording of the bill. The bill says that Rwanda is safe and must be taken as such for a variety of purposes, and Parliament's judgment on that will stand, as far as I can see, until new legislation is passed. And that is why the Noble Lord Hope's amendments 2 and 3, are interesting. Now, I should say I cannot support them as they are, because they essentially transfer authority to the Treaties Monitoring Committee to determine whether Rwanda remains a safe country, based on the compliance or otherwise with the treaty. Now, I don't think that can be right, because the bill is intended specifically to give Parliament that authority, and Parliament should, in theory at least, retain the option to consider breaches of the treaty and nevertheless conclude that Rwanda remains a safe country for the purposes of the bill.
Well, my right honourable learned friend give way.
I give way.
I'm very grateful for my right honourable learned friend. He makes a very powerful point, which I have much sympathy with myself. Isn't there something to be said for the government thinking between now and future stages in a way which might be capable of reconciling the legitimate concerns of Lord Hope's amendment, which is, I think, fair and honest, because facts change. And if Parliament sets itself up as an arbiter and decider on fact, it must have a means of changing its decision if the facts change, just as anything else would. Keynes comes to mind, I'd say, to the Minister. Can we find a way forward on that?
My honourable learned friend anticipates my conclusion. I agree with him entirely. In fact, he in advance agrees with me entirely. But I'm conscious my honourable friend also wished to speak.
Giving way. I was just keen to hear further on how he would see Parliament's role in assessing any future breaches of the treaty in light of what he has said.
Yes, I'm grateful, my friend. And essentially, it seems to me that Amendments 2 and 3, though, as I say, they are flawed, they do raise the valid issue of what happens if Rwanda at any point falls below the standards expected of it to justify safe country status. Now, the bill establishes in legislation the largely unchallengeable conclusion that Rwanda is a safe country for the purposes of the bill. because Parliament says so, without any mechanism for Parliament to say differently if the facts change, save, of course, presumably for fresh primary legislation. I give way to Honourable.
I thank the honourable gentleman for giving way. What concerns me about what he's saying is, and I see almost two contradictions coming there. On a one level, the honourable member is saying about the sovereignty of Parliament, and then the issue about whether Rwanda is safe or not can be changed. But then we have a situation where our Supreme Court, the highest court in the land, said, after reading all the evidence, that Rwanda was not safe. And for Parliament, and yes, it is sovereign, but it's become almost a dictatorship, because it's a bit like saying a person A was found guilty in a criminal court, but because we here in Parliament don't like that, that person therefore must return back to court and be sentenced. And it's like, you know, using parliamentary sovereignty in the most nonsensical way.
I'm afraid I don't accept what the Honourable Lady says. First of all, and I think the Minister made this clear, the government hasn't ignored the conclusions of the Supreme Court, which we must remind ourselves were in 2022. They have responded to those concerns, and new information is now available for Parliament to consider. And my point is that this is, on the government's invitation, for Parliament to decide and to determine whether we consider that it is, on the evidence available to us, a safe country. We may all reach different conclusions about that. But the premise of this legislation is taking into account the concerns the Supreme Court have expressed. It is nonetheless for Parliament to determine whether Rwanda is a safe country or not for the purposes of this legislation. I simply say that for Parliament not to be able to say differently if the facts were to change, save for primary legislation, is simply not sensible. I think we all hope, perhaps expect, that Rwanda will remain a safe place for migrants to go. But if we could guarantee that indefinitely, we would not need the treaty the government worked so hard to secure, or the monitoring committee designed to scrutinise compliance with it. So it seems to me that although the government is entitled to reject the amendments before us today, it should give some thought to the situation that the bill is now in, breaking new ground to give Parliament specific authority over a judgment which will bind many, but which Parliament cannot easily revise, even if it comes to believe that revision is necessary. The treaty and the monitoring of its terms do provide a mechanism for Parliament to be alerted to significant changes in compliance, and I would ask my right honourable friend the Minister, and indeed his colleagues in the other place, to consider how Parliament may be given further scope to engage with this judgment if the need arises. Now, I do, Mr Deputy Speaker, appreciate the government itself retains means by which it can revise its judgment of the safety of Rwanda. But the government has, in this legislation, clearly and deliberately transferred the judgment on safety to Parliament. And if it's a judgment in Parliament's name, it must be right for Parliament to retain the capacity to reconsider it and, if necessary, to revise it.
Alison Thewlis.
Thank you very much, Mr Deputy Speaker. It remains the position of the SNP that this is an absolutely irredeemably awful bill. We do not support the Rwanda plan. We think it is both an offence to humanity and an absolutely egregious waste of public money, particularly at a time when many of our own constituents are struggling to feed themselves. I thank the Lords for their work on this bill, for attempting at least to try and make this bill in some way better. And we would support all of the Lords' amendments to this bill for what they attempt to do with it. Looking first to Lord's Amendment 1, Lord Coker's amendment adding an amendment to comply with domestic and international law. Well, that really should be the very basic for any legislation coming forward in this place. It should abide by domestic and international law. It seems absolutely ludicrous that we have a bill coming in front of us that doesn't abide by international and domestic law. it's a bit of a cheek of the minister to talk about Rwanda abiding by treaties when and asking them to keep their loyalties to this treaty, while at the same time the Tories are going about the business of undermining the UK's own international commitments on some things that we in fact helped to draft ourselves in some of these international agreements. Things like the ECHR, the Refugee Convention, the International Covenant on Civil and Political Rights, the Council of Europe Convention on Action Against Trafficking, as well as customary international law. All of the and domestic laws, these are all things that we have created here that the government is set about undermining. It is absolutely ludicrous, and it really brings into question the government's commitment to these international agreements, particularly to the Convention on Human Rights, which underpins so much. And we heard from honourable members earlier about the significance of some of this legislation to other things like the Good Friday Agreement, and indeed to Scotland's own devolution settlement. All of this the government seems fit to undermine by its actions.
Absolutely. I'm sure she will have read the report of the Joint Committee on Human Rights on this bill, and we noted that other nations may be influenced by the way in which the UK treats its international treaty obligations. And in particular, we noticed that the Prime Minister of Pakistan has referred to the UK's Rwandan policy in defence of his country's decision to expel from Pakistan hundreds of Afghans who'd fled from the Taliban regime. Does she agree with me that that's most regrettable, that he should be able to refer to the UK's cavalier attitude towards international law to support his own cavalier attitude?
I absolutely agree with the point she's making here. And other countries around the world will be looking, have looked in the past to the UK as an upholder of rights, as a beacon of democracy and of human rights. And now, with this tawdry bill today, you can see how other countries are now looking at the UK's descent away from those international norms that they themselves set up. I'm going to make a little bit of progress because I'm mindful of what the Deputy Speaker said about time. I want to touch also on some of the misinformation that was put forward about Rwanda by the Minister and about UNHCR. Now, the transit agreements are not the same, not the same at all as people being permanently relocated to Rwanda. And the UNHCR have mentioned that Norway, Sweden, Canada, France, Belgium, the Netherlands, Finland and the USA have taken people from 10 countries, including Sudan and Cameroon, to Libya, to the transit camps in Rwanda, and are then being moved on somewhere else. They're not staying in Rwanda permanently, and indeed reports from that transit camp have highlighted that people have no desire to stay in Rwanda from those transit camps because of the conditions in which people are living. So it is not the same thing at all that the government is talking about here, and they should be absolutely clear on that and not mislead the House by things that suit their own arguments. Moving to Lord's Amendment 2 in the name of Lord Hope of Craighead, this is an amendment to ensure that Rwanda can only be designated as safe if the treaty is adhered to. And I think it's quite important here that we recognise, it says that this says it will be a safe country when and so long as the arrangements provided for in the Rwanda Treaty have been fully implemented and are being adhered to in practice. And some of the concerns of the Supreme Court on this matter was that Rwanda are not yet in the place where they can adhere to all of these things in practice. Perhaps they will in the future, but it is not safe now. To declare it completely safe in all circumstances right now is a false argument. And further, in Lord's Amendment 3, I think it's perfectly reasonable that I'm just going to make this point on Lord's Amendment 3, if she doesn't mind. I think it's perfectly reasonable that the government should come and report to Parliament on the terms of this treaty and how they're being monitored. What is the government afraid of? After all, if they think it's safe, if they think it's fine, why do they not want any scrutiny of this matter? Because it is indeed a situation that needs monitoring. There are continued reports of the Rwandan-backed M23 rebels and what they are doing on that country's borders. This legislation is a very poor way of setting safety. It's not flexible, it's not reasonable, it is not able to take account of changing circumstances. And sometimes those circumstances could change quite rapidly and quite unexpectedly, but yet we are legislating here to make Rwanda safe in all circumstances in perpetuity. That is clearly a ludicrous position, and it is a hostage to fortune, and the government should be aware of that. I will.
Anyway, she's making the point that things change with time. does she accept that many things have been put in place both by the UK government and the Rwandan government since the judgment of the Supreme Court in the UK last year?
It's difficult to tell that because there isn't the scrutiny mechanisms in place to allow for committees of this House to ascertain if that is entirely the case. Now, I know my honourable friend's committee has been to visit Rwanda, has some information that she is hoping to share with that, as indeed I understand she has been on that trip as well. But that's not really good enough. There needs to be further continued scrutiny, and I think that is important that Parliament has the opportunity to do that. And I know from the Chair of the Home Affairs Select Committee that information, even information on this deal, has been difficult to come by. We had the debate last week in Parliament about the obfuscation and all the secrecy around the costs of the Rwanda plan. If this is how the government is beginning this journey, we have no confidence on this side of the House, certainly, that they cannot be trusted. So hence why this Lord's Amendment 3 is quite so important. There needs to be a scrutiny mechanism coming back to the House. I'm conscious of what the Deputy Speaker said around time, and I would like to make some progress here. Turning to Lord's Amendments 4, Lord Anderson of Ipswich talks about every decision maker must conclusively treat the Republic of Rwanda as is important. If you don't allow judges, decision makers to take decisions on the basis of evidence, merely on a bit of government legislation set in a small period of time, the government has absolutely zero credibility here at all. You're asking people to blindfold themselves to any other circumstances, to not hear any evidence, to not hear any proof that this is true. And I think that there must be the opportunity for every decision maker to treat to that evidence with the due diligence that we would all expect of that process. Moving to Lord's Amendment 5, this removes parts of the bill which state that Rwanda should automatically be considered a safe country and provide a rebuttal mechanism for the assertion of safety in Rwanda and liberty. So that this amendment corrects a deficiency in the bill whereby Parliament is asked to state that Rwanda is and will continue to be safe, and there is no mechanism by which this can be revisited. It's a moderate safeguard to put this in the bill, which the government should, if they actually thought about this any, would think this enhances the bill, but they are, of course, rejecting all amendments, regardless of where they have come from. Moving to Lord's Amendment 6, this effectively restores the powers of the courts to make factual judgments in the safety of Rwanda for an individual case or for a group of people who share characteristics such as LGBTQ people. And I think it's quite telling that the government minister said that this completely undermines the purpose of the bill. Well, good, is all I can say to that. They should be trying to undermine the purpose of this bill if the notion is to remove people such as LGBTQ people without allowing them to check the circumstances before they ship them off to a country that may not welcome them in all circumstances. I think it's perfectly reasonable that there should be the ability to make judgments of this case. And I recall when we looked, I think, at the illegal migration bill, there was a list of countries at the back of that bill which had exemptions for particular groups of people, even for men or for women, to those countries. This bill doesn't even do that. So I think it's quite reasonable that there should be some way of interrogating this power in the bill. Lord's Amendment 7 from Baroness Lister concerns age-related issues and unaccompanied children. And I think this is an issue actually of the utmost importance. The treaty makes provisions for what happens if a child somehow mysteriously ends up in Rwanda by mistake. Well, that mistake only happens because the Home Office has made some kind of error in sending them there in the first place. We know from hearing from medical professionals that some of the age assessment is effectively pseudoscience. We know that children who have come here, having crossed seas and continents and war zones through very difficult circumstances, well, of course, it might be more difficult. It might be more difficult to assess their age because they've had an awful lot of a tough paper round than my son, for example. And we know that not all children look exactly the same, present exactly the same, even though they may be the same age. We can all think of when we were at school, there was always some great big guy who had a beard and a hairy chest, and the rest of the people were just knee-high to a buttercup. This is perhaps, well, the honourable member says not our convent school, but that's other questions, I suppose. But everybody is different. Everybody is different. You cannot reliably look at somebody and tell their age. And I think there needs to be more protections put into this bill to ensure that children who have already gone through incredibly traumatic experiences do not get sent to Rwanda. This should certainly be within the bill here as well. Moving to Lord's Amendments 8, I'm conscious of what has said in time. I'm sure she wants to come and make a speech on this later on this particular point. We will all listen to that. Moving to Lord's Amendment 8, this adds again a reporting mechanism to Parliament. Removals to Rwanda under the Illegal Migration Act 2023 within 60 days of the date on which this act is passed. The Secretary of State must present leave before Parliament a statement. And I think this again is an important scrutiny mechanism. We should know in this Parliament who is being sent to Rwanda. We should know the timetable for those removals as this amendment suggests. And I think most importantly of this amendment, point C, is the arrangements in place for people who are not sent to Rwanda, because we know that only the tiniest of percentages of people who've ended up here will be sent to Rwanda. It's entirely unrealistic to suggest more than a few hundred people, if that, ever will get sent. So we need to know what happens to those people that end up in immigration limbo, those people that are inadmissible. What happens to those people? Where are they? Who looks after them? Where do they live? How do they survive? What do they eat? We need to know what happens to the people that this government is committing to immigration limbo, because it is important, and I think the government should be updating Parliament. The Minister talked about publishing of immigration statistics. I think it needs to be more than that. This House needs to hold the government accountable for the people it sends, for the people that it doesn't send. And I think the point around the timetable of removals is also important, because I am aware, Mr Deputy Speaker, of people in Dungavel who are quite keen to leave the UK, and the UK government's taking an absolute age to arrange the mechanisms for them to do so. So even for people who want to leave and have reason to leave and go somewhere else, the government is not facilitating that at the moment. So the timetable for those removals is also quite important. And I think it was quite worrying that the Minister said that it is not necessary to report this to Parliament. I would disagree. It's entirely important and necessary to report this to Parliament so we can hold the government accountable. And again, if they think it's going to go so well, sure, they'll want to tell us how many people they've sent away, rather than those that they don't. Moving on to Lord's Amendment 9 on victims of modern slavery and human trafficking being removed without